The General Council of the Bar of South Africa and the Advocates for Transformation have dragged government to court over a R500 million National Treasury tender. They claim the State Attorney's Office rendered advocates non-tax compliant by not paying them on time, leading to them not meeting the requirements to be part of Treasury's legal panel. Finance Minister Enoch and Justice and Correctional Services Minister Ronald Lamola are the defendants. I'm joined now by Advocate Don Mahon from the General Council of the Bar for South Africa. Thank you very much, Advocate Mahon, for joining us on SA Tonight this evening. So first off, legal terms can be quite confusing for those of us not in the in the profession. So perhaps in simple terms, you can explain to us the basis of the case you've brought against Finance Minister Enoch and Minister of Correctional Services Ronald Lamola around this tender that you've called unlawful.
Yes, thank you for having me. Let me start by saying, as you know, that the state is the largest consumer of legal services in the country. This places it in a position to greatly influence transformation of state legal services and the legal profession. And that influence is seminal to redressing past imbalances and inequalities that are pervasive in their impact upon particularly black and female legal practitioners in the country. And the state's intention to advance these imperatives through the preferential procurement of legal services from black and female advocates, particularly junior advocates, is something that we applaud. And I speak for the GCB, and I'm sure I speak for Advocates for Transformation and indeed all referral advocates. But where the state implements a policy which undermines those imperatives, it is the same black and female advocates, particularly juniors, who are most adversely affected. The state published on the 5th of October an intention or an invitation for advocates to tender to be placed on a panel for a period of 36 months. And firstly, the closing date for the tender was published to be the 6th of November at that time. So as you can imagine, we were taken somewhat by surprise. We attempted to engage with the Office of the Solicitor General and the Minister, but unfortunately our requests that the closing date for the tender be deferred was not acceded to, and we were thus left with no option but to bring an application to court. Now, the application concerns the legality and rationality of a bidding process which will lead to the composition of this panel. There are a number of legal challenges, and I'm sure you'll appreciate that I don't want to get too much into the merits of the matter, given that the case is still pending. But we say that the very notion of this tender system is inimical to the very foundational tenets of the advocates profession, the referral advocates profession. We say it undermines what we call the cab rank rule, which exists to ensure that the freedom of the accused to be represented by an advocate, as whoever that advocate is, as long as he's available and there's an agreement on the fee. That rule, we say, is undermined by the tendering system. And the special conditions of the tender contemplate what is called a transversal contract, which contemplates a contract being concluded between the advocate, the state attorney, and National Treasury. Now, we say that completely undermines the very foundational tenet of the referral profession. And indeed, we believe that it would be unethical, according to long-established rules of the profession, to enter into a contract directly with the client. There are a number of other challenges to the system. The fact that it prescribes certain fee parameters which are completely unrelated to market forces. We say it will force particularly black and junior female advocates who survive on state attorney work primarily, to be forced to accept briefs and give quotations for work, which will result in them having to work for fees which are completely not market related, thus, as we say, undermining the very transformation imperatives which we believe the state is trying to promote. In addition to that, the advocates profession is one which can't simply be reduced to rates and hourly charges. As advocates progress in their careers, they become more distinguished and thus are able to command certain fees. And we believe that those advocates will be lost to the state if this system is implemented, because why would they accept the arbitrary and quite frankly irrational rates which are foisted upon them when, having earned the distinction, they would otherwise be able to get work in the private sector?
Could you talk to me a little bit about this late payment, especially of junior advocates for state work, and the position that's put them in with regards to being not being tax compliant and not being able to partake in this tender, and also what what's been called a shambles at the state attorney?
Well, over the last few years, and I hope I'm not being too critical, over the last few years, the offices of the state attorney have been severely chastised by the courts. In one case, the Pretoria State Attorney's Office was described as dysfunctional. So from the perspective of the GCB and AFT, it can responsibly be said that the dysfunction in the Office of the State Attorney is completely endemic throughout South Africa, and that not only advocates but also state departments are adversely affected. There are numerous instances of counsel doing work for the state and either not getting paid or being paid late. We receive regular complaints, particularly from the most vulnerable members of our profession, which are black and female advocates of 3 years seniority and below, complaining that having done work for the state, they simply haven't been paid, despite the lapse of months, sometimes years. That causes a cyclical problem, because in many instances, they've had to render VAT invoices, and they haven't been able to pay the VAT because they haven't been able to collect the fees. The result of that is that they can't get a tax clearance certificate. And if you can't get a tax clearance certificate, then you are rendered ineligible for state work. And so by virtue of what the state is doing, those advocates become unable to continue doing state work.
Thank you so much for your insights. It does seem to be a complex issue, but we'll be keeping an eye on the outcome of this court action. That was Advocate Don Mahon, who is the chairperson of the General Council of the Bar of South Africa.